Hi, everyone. It's Jim Burtnick from Sotheby's Real Estate and the Silver Burtnick and Associates team. Today I'm here with my friend David Kelman from Schwartz and Schwartz. He's a lawyer and he's going to talk to us about a very important topic that we find coming up a lot right now, which is probate and title to real estate assets. So thank you for joining us, David.
Thank you, Jim.
Dave, let's dive right into it. Probate. Hearing a lot about it these days and a lot about delays in probate. Tell us a little bit about it, what it is, and what's going on in that field.
Okay, so probate comes from the same word as prove. And the idea is that if you have a will, which, a will sets out the disposition of your assets after you die. Probate is the process where the will goes to a court with an application, and the court has you prove the will, and the end of the probate process is the appointment of an estate trustee. So the estate trustee will be the person named in the will who's going to help you deal with the assets of your estate after you die. And one of the problems that people are, particularly in the city of Toronto, are finding is that a loved one has died. They've been appointed the trustee of the estate. They hold an asset like a real property asset, a house or a condo, an apartment, whatever it is. And they can't deal with the property until the court has appointed them as the estate trustee officially for everyone to see. So that probate process is supposed to take a number of months, and it can drag on 8, 9 months. A year is not uncommon now. So imagine a loved one of yours dies and you want to sell the house that a parent or someone owned, and you cannot do a thing until 8, 9, 10 months have passed. And it can be really problematic, particularly as markets go up and down. Or as when you want to be able to access those funds.
Or carrying costs.
Carrying costs are an issue too. And imagine you have a mortgage that expires in the middle of that probate process, and you can't refinance the property, not easily, unless you have that probate certificate. In terms of the delays, I can't tell you what's going on behind the doors at the Estates Court in Toronto. I only get clues through my dealings with the Estates Court. I did hear that their service standard is what they call it, that their service standard is 13 weeks, 3 months, not that bad. And that's more or less what you can expect in Newmarket, Oshawa, Brampton. But in the city of Toronto, either for staffing issues or I'm not exactly sure why, it takes a lot longer. And I've had situations where I'd actually go down to the Estates Court. There is a process where you can file for probate electronically as well as in paper. I always use the paper process because it's what I know and it works well. And I've heard about problems with the electronic process. But in order to deal with a paper process, you have to go in person to the court.
Right.
Even though they'll send me something from the court that says, oh, you need to correct this or do this with your application. I had a situation where I replied to them instantly, like within an hour, and then heard nothing and would follow up every week and hear nothing, until I actually had to show up at the court and say, why aren't you responding to my calls, to my emails, to nothing? And then I had someone help me, and then she disappeared. And it was just incredible the way things were not working there. So there are ways to avoid probate, and I think that's maybe where you're going with your next question.
Well, yeah, one of the things we've certainly found is a lot of our clients, in this city, the executors for people in probate are facing this delay. And as you say, they can miss timing the market at a peak. They can have all these carrying costs that they have to finance out of pocket in the meantime. And there are ways, and I know you helped a client of mine recently circumnavigate around that to get to a position where they were able to sell shortly after their mother passed away.
Right. So let me differentiate a couple of things, which we hadn't talked about before. But keep in mind that probate is an estate, um, like a part of the state's law, as opposed to real property, real estate law. In that people have assets that aren't just houses, real estate assets. They have bank accounts, for example, that are in their name solely. They may have other assets.
Safety deposit box.
Yeah. So
things.
the long and short of it is to get around the need to probate any particular asset, that asset has to be held jointly. And there's certainly more to explain about that. But let's say you have a bank account, or mom has a bank account. If someone's name gets added to the bank account, so the bank account is held jointly, then the way it works with joint ownership, it includes a right of survivorship, which again we'll talk more about. That right of survivorship means that when mom, as an example, dies, the law deems the property, mom's rights in the property, to go automatically to the other joint holder, the survivor. That's the right of survivorship. So just because an asset is put into one or another asset is put into joint tenancy and avoids probate doesn't mean you don't need probate. It means you don't need probate for that asset. So when we say that we're putting something in jointly and avoiding probate, doesn't mean that you're avoiding probate for everything. And we're talking specifically about using legal methods to avoid probate for specific assets. In this case, real property assets.
Correct. A residential house is why we're.
And they tend to be the assets that have the most value and are the most likely to be sold. But keep in mind, if you have a bank account with a lot of money, your estate is not going to be able to access that if it's not held jointly. So remember, Jim, when we're talking about probate, probate relates to all of the assets in an estate. So you might have a house, you might have a bank account, you might have any number of other assets.
Right.
Just because you put one asset and avoided probate for one doesn't mean you're not avoiding it for the other assets.
Makes sense.
So a proper plan made with a lawyer or an estate planner or someone like that is going to be important for anyone who has multiple assets. In terms of dealing with real estate, yes, we can talk about it.
Let's talk a little bit more about it. Talked about a house. They've owned this house for 40, 50 years in Toronto. Unfortunately, their time has come. They're passing away, or they know they're passing away. What can we put in place to circumvent the probate as it relates to the real property so that people can continue on with their lives and get it sold?
Right. Well, I think one important thing to say right from the beginning is don't do nothing. Do something.
All right.
At least be aware of what your options are. And I've certainly had people come to me and hear what I'm about to say, the advice that I give, and decide not to do anything. But at least they've made an informed decision rather than not doing anything and then finding, and then leaving it to their kids to work out, because very often it doesn't work out well for their kids. So when people come to me, I'll give you an example of my own family. My mother's oldest sister, Auntie Molly. She called me a number of years ago and said, I think I should put the kids on title to my condo. And that's the holding jointly to avoid probate because of the right of survivorship. So I told her that, yes, this was very common. She used to sell real estate, so she knows a thing or two. And I said, it was very common that we would do it as just a matter of course. And it's less common now. And there's 3 reasons why we warn against it, 3 pitfalls. Whereas there's a good thing about it, and that is you don't have to pay probate. You should know, and I didn't mention this before, probate, the estate administration tax is what is also known as a probate fee. In Ontario, it's about 1.5%
Right.
of the value of the property as of the date of death. So on $1 million, the probate fee is $15,000. It's not nothing.
Right.
Okay, so you have that on one side of the scale. On the other side of the scale, you have 3 problems. One of the problems is that by giving a gift of a portion of your property, you lose control over the property. So you give a gift. Let's say I own a property and I give a joint tenancy to you. So now you're a part owner of that property. You are actually the owner of 100% of that property together with me. Then the next day I say, okay, Jim, we're going to sell this property. And Jim says, no, we're not. I don't want to sell the property. But now I have a problem. So I've given up control over the property.
You need everybody to agree.
You need everybody to agree. And the parent doesn't necessarily want to give up control of the property to a child, especially if you don't know. I mean, we don't control other people. We don't know what they're going to say. So that's the biggest issue. And that's one that we're going to address a little bit more later. The other two issues are one, family law issue. If your adult children are married and there's a breakdown of the marriage and you've just given them an asset, then that asset can be subject to an equalization under that. You've given them an asset that now could be lost wholly or partly. And most parents don't want to do that, don't want to take that chance. Well, that's something that, of course, depends on the situation, but it's something to keep in mind. And the third is another type of tax that we haven't talked about is capital gains.
Right.
And we know that for a principal residence, you're exempt from capital gains, but it has to be your residence. Your kids don't live with you, if you're lucky. So to the extent that the kids have, let's say, and I said this to my aunt, okay, Auntie Molly, well, if you give my cousin the property now and you hold the property and you're going to live a long, long life, you hold the property for 10 or 20 years, they're not living there. There's a potential that they would have to pay capital gains tax, which is a 25% tax on the increase in value. And of course, we know that over time, properties increase in value. My advice to my aunt was to wait. Don't do it, but maybe do it. It's awful to say, but maybe do it when you can kind of see the end coming. When you're getting old, you're getting slower, maybe you're ill or whatever, and you have the time to plan. The other thing to say about all of this is, yes, it's good to avoid probate if you can, but receiving a gift of the property, even if it's subject to a 1.5% tax, it's still a nice thing to receive that gift. So there's some weight to be had. And I have to say, I just got a probate certificate yesterday for a client. I was not expecting it until September, October. It's July now. And I wasn't expecting it September, October, November. So maybe the city is getting a little bit faster. There's no guarantees. Okay, so we've seen these three pitfalls.
Right.
Then the natural question that comes out of it as well is it worth doing anyway? Or are there any ways to sort of get around those pitfalls?
Exactly.
And the first one in terms of control, I think that there is a way. And doing the research, it comes out of this case, this 2009 case.
Telling me about this one out of BC, right?
Yeah, and it was a case called PCOR and PCOR. Now, I'm not going to give you the details of the case because I don't really remember the details that well. I do remember what the case stands for. And it's the idea that when you give one of these gifts, so let's say that you have a will, and the will names your 3 children, for example, as beneficiaries. But you give a gift of the joint tenancy, not to all 3, but to one of them. This was what happened in PCOR. And then you die. The property goes to that one person one person who received the gift says, the house is mine. It's mine now by my right of survivorship. And then the other 2 kids say, but wait a second.
Right.
You intended by the terms of your will or something you said, or I think in that case it was a will, you intended that all 3 of us share in this house.
Equally, yeah.
Right. And there was no evidence about what the person actually wanted. When they went into the lawyer, the lawyer didn't take notes, or for whatever reason, the court had to decide. And what the court came up with was the concept of a resulting trust. I'm not going to get into trust law too deeply, but the idea is that if there's it's called a rebuttable presumption, which means that if there's nothing, then the presumption is that the person who is given the gift in joint tenancy is holding in trust for themselves and for the other people
Named in the will.
in that case.
Right.
Yeah. But that presumption could be rebutted. For example, if the person who was given the gift had notes from that time or a signed document from the parents saying, my intention was to give you the gift solely, not to anybody else. And look, it happens. Parents don't necessarily want to. They may have one kid that they want to give the house to that the other ones don't need. Maybe one kid isn't doing as well as the other. There's all sorts of reasons to do it different ways. The court is not going to infer anything. And so the best advice that I can give people is to make clear what it is that you're doing and why, so that the lawyer at least takes some notes. And preferably you sign some kind of retainer acknowledgement saying what your intentions in doing things were. Doesn't mean you can't change things. You can potentially change things over time. And that's the next issue to talk about. So what I found through my research is that lawyers were doing something new related to joint tenancy.
Mm-hmm.
So keep in mind what joint tenancy is. Joint tenancy has two components. It's got an ownership component and a survivorship component that we talked about. So the way it works is if you and I hold a property as joint tenants, and I'll be nice and say that I'm the one who dies.
Fair enough.
Okay, you become the joint tenant. You become the owner by right of survivorship.
Right.
So that no matter what my will says, that because of the right of survivorship, the way the law looks at it is the moment before that I died, I gave the property, my right in the property, over to you. That's the way the right of survivorship works. So the question is, can these be separated? And what I think it started actually in BC as a result of that case is some lawyers were doing a structure that allowed the gift just of the right of survivorship without the ownership right being transferred. So that would mean that something like the family law problem that we talked about and the capital gains problem, as well as the initial problem of control's a little bit tougher, are all dealt with by just gifting the right of survivorship without an ownership interest until the time that the person dies. The problem is, and I've done this before for clients, the problem is it's hard to know whether it works for all of those things because we haven't seen the question challenged by the CRA yet. So we don't know about the capital gains for sure. And also, I don't think we've seen it challenged in a family law context, where they're saying, yes, you have actually given that gift now. Now that there's a breakdown of marriage, I get a portion of that as the other spouse. So, and in Ontario, there's nothing on title that actually shows. When it shows joint tenancy, it includes the right of survivorship. It doesn't just say right of survivorship without ownership. Maybe the law will change around that. So what I do, and I've done it for clients, is set everything out as clearly as possible in a retainer letter and an acknowledgement for everyone of how it all works. The question of whether the right of survivorship gifted by itself without ownership can be revoked, because you can't easily revoke a joint tenancy. Once you give the gift, you can't take it back.
Right.
All you can do is sever the joint tenancy and just have a 50-50 ownership, or depending on how many people. So it is fraught, and the best thing is to get proper advice, to make sure that your lawyer knows exactly why you're doing things and that everything is papered properly. And if possible, let the beneficiaries or the person you're giving joint tenancy to, let them know what you want. Let them know what your intentions are. That means you have less of a likelihood of there being a court case. And I think most parents, they don't want their kids to fight after they die.
Yeah.
And so I think being open is the best way forward. That's not always easy for people. There's ways of doing it without telling everybody. But my best advice for people is to be very open, straightforward about you want. You have to also know what you want.
Right. Makes sense. And I think that entails talking to a lawyer, going through and being educated, as you said, on all the different choices you have, like that you gave Aunt Molly, and then ensuring you've got a will in place so that you've got something that shows everybody what your intentions are.
Right. I think so.
Now, would you say, I'll give you a hypothetical example. I own a house in Toronto. I've owned it for 40 years. I find out that, knock on wood, I've got terminal cancer and my life expectancy is another 8 months. I'm the only one on title. I want to circumvent probate. In that situation, would you recommend that I go and, in this case, put it in joint tenancy with somebody such as my son, so that he will not have to go through the process of probate?
Maybe.
Like a lawyer.
Yeah. There are good reasons to do it, like we've talked about. There are some things, once we talk and get through some of the details, well, is your son married? How's the marriage going?
Right.
I don't think we have the same concerns that we used to because of this new structure, but the concerns are still there. And like I said, there's always things to talk about and decisions to be made. There's no perfect way of doing it. There's always potential problems on one side or the other. Like I said, I think the estate's office in Toronto is maybe getting better. That's also a knock wood.
Right.
So that maybe in the future that won't be as much of an issue as it is now.
We're running into it almost weekly with cases, so I think it's here for the near term at least, to medium term. And so I think this is important information for people who are dealing with this in the present now, 2024, so that they can be prepared as possible. So if I were considering going down this road of circumventing probate in the manner you described, how much lead up time would one need to put this in place so that you are protected?
You know, it's an awful thing for a real estate lawyer to talk about death so much, but you can do it the day that you die. That's like, as long as it's before you die, you can't do it after, that's for sure. In terms of lead time, there's no real right answer, but thinking about it well before is a good idea, and then you kind of make your own plan. But there's no better time really to think about it than now, really.
Well, you've got sound mind, sound health.
That's true, and we didn't even talk about the capacity issue. I mean, there's more and more people who are finding that their family members may lack capacity to make these choices. That's a whole fraught issue in itself in terms of granting a power of attorney for someone to do that, and the difficulties that that would present. For example, if someone came in and said, I have the power of attorney for my father or mother, and they are incapacitated right now, it's a lot to think about. And I'm always happy to talk to people who need that kind of advice, or to, even if they're really just at the point of thinking about it as opposed to doing it. But I get those requests all the time, and I don't think that there's ever a bad time to be thinking about it.
That's one of the things I love about referring clients to yourself and Schwartz and Schwartz. One is, congratulations. I know you're celebrating 75 years.
Thanks.
Schwartz, not yourself, but
No.
You've been doing this for what?
I've been at it since 2002, so 22 years now.
Yeah.
Um,
And so, these are things that I think are important to discuss. And that's why I recommend to all our clients to make sure that they've got sound and good legal advice as it relates. Certainly, you always instill us to make sure we have a will in place and to have these discussions beforehand so that at least you're educated.
for sure.
David, you've given us a lot of information here, and I know it's a lot to process and absorb, and every case is different. With that in mind, what I would tell people watching this is that to speak to a real estate lawyer regarding matters like this and come to an informed decision. And certainly Schwartz and Schwartz and yourself have been great for a number of my clients. The feedback's always been good. So I thank you for your time.
Thank you.
And look forward to discussing more real estate with you in the future.
Thanks. If your clients ever care to reach out to me, They can reach me by phone, they can reach me by email. Very responsive, and as you can tell, I love to talk.
Exactly.